Are you in the middle of a contested divorce and you're wanting to try to reach a resolution without going to trial? My name is Carl Burkhead. I'm an attorney with Worth Law Office in Tulsa, Oklahoma. I've been doing family and criminal law for about 7 years now, and I want to help you make law easy by talking a little bit about how you can take a contested divorce into an uncontested one and hopefully reach a resolution. Um, Courts don't really want you to be in the middle of litigating a divorce. Every judge that I've ever been in front of in the last 7 years has always said, and I agree with it, I've seen it firsthand, parties are going to be happier with an agreement with a decree that they reach by agreement, as opposed to a decree that the judge just shoves down their throat at trial. It's always better, in my opinion, to have at least have one hand on the steering wheel instead of just completely giving up control and praying for the best. So a lot of times in these situations, the courts will order parties to go to mediation. Um, Mediation is basically you would sit down with your lawyer, they would sit down with their lawyer, and there would be a neutral third party. Usually it's another attorney. Sometimes it's not, but it'll be a neutral third party that's going to try to help you identify what the issues are and see what can be done to get creative to solve these problems. Um, it doesn't always work, but 9 times out of 10 it does. And I cannot stress this enough. If you settle at mediation, it doesn't mean you're going to get everything that you want, but it does mean you'll possibly get more than you would get at trial. Mediation, I, I personally believe that a good negotiation, a good compromise is one that nobody walks away from completely happy with, but they do walk away from it with something that they can live with. As opposed to going to trial, it's all or nothing. You're either going to get everything you want or you're not, and there's no real in between there. Uh, I tell my clients a lot of times, like, here's the deal. You can either spend a bunch of money taking this thing to trial. I'm going to take that money and I'm going to take my family to Disney World. Or you can save that money right now, pocket it yourself, reach a resolution, and then you can go to Disney World. Usually when I put it in those terms, I don't end up getting to go to Disney World because people kind of they basically run the cost benefit analysis and decide that it's better off to not run the risk and not have to pay for the risk and to just try to settle something at mediation. It doesn't always work though. And if it doesn't work, that doesn't mean that you've done anything wrong. It just means that it doesn't work. Sometimes there's just no middle ground. I had a case a few years ago where my client and the other side, they lived worlds apart. I mean, states away. And so, ironically, we're arguing about who gets custody and who would get visitation. Ironically, even though there's literally geographically just miles of middle ground, just metaphorically, there was no middle ground between the two because there wasn't a whole lot that we could do to negotiate. I mean, both sides were basically saying, hey, I want the kid. You can have every holiday, but I want the kid full time. Neither one can really budge. There's not extra visitation that you could offer in that situation. And in those situations, you just got to go to trial and hope for the best. My honest advice, though, and I give this to every single one of my clients, is at least try to settle. Try to act in good faith to negotiate something that you can live with. If you have questions about this, if you're wanting to try to get off the trial track and reach a resolution, or you're wanting to try to make sure that you don't even get on the contested track in the first place, absolutely give us a call. My name is Carl Burkhead. I'm with Worth Law Office, and I want to help you make law easy. Thank you.